All rise. The Florida Supreme Court is now in session. Please be seated.
We'll now take up case number 2023-0079, Sexton versus State of Florida.
May it please the court. I'm Karen Kinney on behalf of John Sexton. This is a capital direct appeal from a resentencing. I'm asking this court to reverse for a new penalty phase based on a number of errors, starting with the denial of funds for the private court-appointed attorney to do the investigation, and culminating in a sentencing order that bears little resemblance to what actually occurred at this penalty phase trial. Starting with the denial of funds to investigate the mitigation, I'd like to address the standard of review, because normally I agree that that would be an abuse of discretion standard to look at an order on denying investigation funds. But in this case, we have the fact that the U.S. Supreme Court has spoken many times on what the prevailing professional norms are in a capital investigation. And in this case, the standard of review has to be informed by what the court has said in terms of what the Sixth Amendment requires a private attorney to do.
What's the particularized need for travel to Oregon and Arkansas in this case in 2023 when I think there are sufficient means available for obtaining the information needed by means other than travel? Can you articulate why that's necessary? Why you're saying we don't need to be asking why it's an abuse of discretion, but if I'm not asking whether it's an abuse of discretion, what question do you propose I ask?
Well, the need is going to what the Supreme Court requires of an attorney who is representing a capital client.
Which Supreme Court case says that an attorney defending a capital client must travel to visit mitigation experts rather than obtain their sworn affidavits or talk to them on the phone? Which case says that?
The case of Wiggins versus Smith talks about the ABA guidelines. And the ABA guidelines talk about the standards for a defense, and it's not talking about a Cadillac defense, it's talking about a reasonable and necessary defense. And those standards require investigation of witnesses that is a face-to-face investigation. And so the travel is necessary, and it's also part of the prevailing norms of what is done in these cases. And that is all part of what the court discusses in Wiggins versus Smith and in Porter versus McCollum, that the investigation has to comport with the prevailing norms. And so if in this case, even at when the mitigation expert was called to testify by the court, she said there were people I couldn't go to see because these people, this is a very sensitive investigation.
Do you argue that this wrought a deprivation of counsel in violation of the Sixth Amendment?
Yes, that's why there's an element of a pure question of law that has to go into the abuse of discretion standard. Just like the discretion has to be informed by the Supreme Court cases that describe what a competent Sixth Amendment investigation would be in a capital case.
Seems like a very heavy burden for you to shoulder.
Well, it's not because, I mean, anytime you have, I mean, in this case, I think it was, the amount of money that was being asked for was not a lot of money, and the judge was being unreasonable in denying it. Even when the defense attorney said, how about if I just allow some of the other, take some of the money away from the other experts and allow this to occur, I need this mitigation, I need my specialist to go and seek out these people. The judge said, no, I'm not going to have a negotiation about this. So he was really just being unreasonable, and that also goes to the question of him denying the brain scans. We're not talking about a lot of money, but we are talking about the question of whether or not the client had organic brain damage. And the defense attorney had gone and told the judge, I have expert witnesses that have recommended this, and the judge thought that, well, it doesn't matter whatever his problems are, it doesn't matter if he has organic brain damage, that's not something that you need to discern.
Well, isn't it true that we also have to ask what prejudice was wrought by this. And isn't it true that Sexton's sister basically established the fact that he had been abused? Isn't that, no one's really disputing that fact in mitigation. So what's the prejudice that ultimately resulted as a result of this decision by the trial court, even if we agree that it was an erroneous decision?
Not to allow the travel.
Yeah.
Okay,
what prejudice, what was the prejudice that resulted from that, given the stipulation, not stipulation, but the more or less, the evidence in the record that the court did have with respect to the very points in mitigation that you're saying you needed to travel in order to establish?
Actually, we didn't know what was going to be established, and so it's putting the cart before the horse to say that the defense needs to show what the mitigation is going to turn up, and the defense attorney even made this point, I can be looking for positive mitigation, which the defense case that he put on was about positive mitigation. So it's putting an impossible burden on the defense to say, in this situation, tell us what that investigation would have turned up.
I don't know. I think our cases establish pretty clearly that you have to show prejudice. I don't know that. Are you saying that it is impossible to establish prejudice on facts like these, that we should give up that part of our case law?
I'm saying there was prejudice, and it was established because.
So what is the prejudice? What changed as a result of the lack of access to funds for these trips? Because what I hear you saying is, I don't know what the harm was. I can't tell you what the prejudice is because the prejudice is in the things I don't know. But that won't do under our cases. We do require a showing of prejudice, and I don't hear you articulating what the prejudice actually was in light of what we also know.
Well, I think you're talking about prejudice in a different way than I am, because it's almost like you're saying we need to establish prejudice as if this were a post-conviction proceeding where we would now tell you what we would have found out if we had the funding. But we can't do that because until there is a post-conviction proceeding and somebody goes and makes these trips and looks into his life and tries to find these witnesses that she couldn't get on the phone. So we can't do that. So the prejudice is that the mitigation expert wasn't able to talk to some of the people that she wanted to talk to because she couldn't go and do her job. That's what she is trained for. So obviously, it's not going to be, this is sort of a unique situation because we're talking about a capital case where there's a Sixth Amendment right to an investigation that is supposed to be very comprehensive as I read the U.S. Supreme Court cases. And it is not enough to say there was a rudimentary investigation based on a narrow set of witnesses. So I think the prejudice is that we didn't get to do the mitigation that was necessary in a capital case.
Would you mind if I redirected you just slightly?
Sure.
Can we talk a little bit about whether the trial court truly misunderstood its discretion to impose the death sentence as illuminated by its statement that the sentence was compelled by the law? Can you say a little bit about what evidence you have that the court was truly under a misimpression about the scope of its discretion, as opposed to this being an unfortunate, perhaps inartful statement? What evidence do you have that the court was actually confused about what it had to decide?
I mean, I'm just looking at exactly what she said, and she said this was she made it like a mathematical equation. These are the aggravators, these are the mitigators, this is the mathematical equation, therefore I am compelled by law. So I'm just taking her at the words that she used, and that's the last thing in the sentencing order. So I think that to take that a different way would be just pure speculation at this point. So I don't know that she understood that she didn't have to.
Well, doesn't the whole existence of this second penalty phase kind of give the lie to that? I mean, it would be a pretty catastrophic misunderstanding of the law to have gone through this process, had a penalty phase trial where precisely this issue is being litigated in light of the whole history of this case, and to then sort of conclude at the last minute that this isn't a discretionary exercise. I guess what I'm struggling with is I agree that those words are incorrect as a statement of law. I think you're right about that. I'm not quite sure what to do with it in light of all of the other evidence in the record that seems to demonstrate that the court knew that those words were wrong. That's what I'm struggling with.
Well, I don't think the court knew those words were wrong, because I think the court did not understand what the job was, and that what in the selection phase, that there is the weighing, but then there is a determination at the end that has to be an individual moral choice, and to say compelled by law is skirting that. So I think that I don't know how to read that any other way than what she said, and but that was just something that I thought was a problem in the case. But going to the second issue, I think that there's a serious problem where Judge Hansel violated Mr. Sexton's constitutional rights by calling the mitigation expert as a court witness to question her about the evidence that Mr. Sexton elected not to present in his case. And he had been very clear about wanting to control the presentation of the mitigation, and he meant to keep certain things out of the record. And this came up in such a roundabout way because the judge initially said she wanted the defense at the beginning of the trial to produce a memo that would go into a sealed place in the record, not for the direct appeal, but just to defeat a future post-conviction motion. So right there, she's acting in a prosecutorial manner, thinking about trying to defeat the post-conviction motion to challenge the death sentence she's going to.
I'm sorry, who did she order?
She ordered the trial attorney for Mr. Sexton to prepare a memo of the items that he had discovered in mitigation that Mr. Sexton would not be presenting in his case, because the defense had put a notice to the court that he was going to be using selective mitigation. And so she said, well, I need this memo that the defense attorney is going to prepare. So the defense attorney had prepared the memo. It never actually came into the record because the the judge kept changing what she was asking. And then Mr. Sexton was objecting to this. And at one point, he even said that, if I fire my lawyers, can I stop this from happening? And she said no. So then that's what was supposed to happen on the second day. And when the case adjourned on the first day, she was talking about, okay, that's going to happen, and prepare to have this memo. But she was going back and forth on whether or not it needed to be put into the record. But when we get to the second day, she says, I've been looking at these cases overnight, and now I think I need this on the record. And then she said, I'm going to have to either have the memo put on the record, or I will call the mitigation specialist as the court witness and ask her these questions myself. So this whole procedure, which Mr. Sexton was vociferously objecting to.
Let me ask you, if counsel had requested that that go on the record and called and put on whatever a proffer from the mitigation expert, had defense counsel suggested that and the court granted it, would that be a problem?
Yes, because the defendant is the person that would be almost akin to like the McCoy versus Louisiana situation, where the court made clear that this is the defendant's right to control what is presented in his case. He has the autonomy, even when he's represented by counsel. So it would be a different claim. It would be maybe a claim of the attorney violating the defendant's rights in that respect.
Doesn't our case law sort of send mixed signals to trial judges on that issue? I mean, it seems like we say that, but then we also seem to have, seems like this nebulous obligation on the court to avail itself of whatever it can get its hands on in terms of mitigation and factor that in. I mean, I don't know that we've said sort of bright line, the defendant is 100% in control, and it would be error for the court to actually go beyond that. I mean, don't we require pre-sentence reports to be prepared regardless of whether the defendant wants it and stuff? I mean, would this be the case for us to sort of make sort of a bright line rule that it's 100% up to the defendant and there's nothing beyond that the court needs to worry about, and that in fact it would be error to go beyond that?
I read this court's cases as being very clear, and so I don't think it's a nebulous situation, because I read this court's cases as saying that this is the defendant's right. The defendant has the autonomy to, and where the judge went off, and I think some of the cases have some language in it, which are the Muhammad cases, where you have someone who's unrepresented, who doesn't want to have a mitigation hearing at all, and says absolutely nothing, I don't want to present anything, and a lot of times they don't want an attorney, which is not the case here. Mr. Sexton wanted an attorney. He just wanted to control the mitigation. And I think it's very clear from this court's cases, the Boyd case, that he had that right. So the confusion was just misreading the Bell case. The judge cites a statement in the Bell case that's talking about the Muhammad situation, where the court can appoint independent counsel. But that is not the case when the defendant is exercising his autonomy to choose some mitigation, which here Mr. Sexton was exercising his autonomy to strategically put on positive mitigation to humanize himself. And he was trying not to put on what happened at the first trial, which didn't end well for him. So the judge just completely missed misread the court's cases, which I think are very clear. And I think that Mr. Sexton knew his rights under that. He was citing McCoy, he was citing Boyd to the court, and he was saying, I'll just fire my lawyers if they're going to be doing that. So it was the judge who thought that she had to do that in order to protect the case, the death sentence, from a review on post-conviction. And
Okay, you can wrap up, and then you can have 2 minutes for rebuttal.
okay. Well, I just think that there were errors, if you look at the third issue, that ended up with a sentencing order that actually is pretty much on the mitigation, exactly word for word, what the first order was in 2013. So this court should reverse this for a new penalty.
Mr. Chief Justice, and may I please the court. My name is Christina Pacheco, and I represent the state of Florida in this case. Turning to the issue, Justice Coriel, that you had mentioned regarding the sentencing order in this case, I would agree with the language that the wording was unfortunate and inartful. However, given what the trial court said throughout the proceedings, I think that it is very clear that we can presume that the trial judge knew her role and that she was permitted to sentence the defendant to either a life sentence or death, and that she was not compelled by law to enforce the death sentence in this case. I think that it's more of a semantics issue. She just as well could have said that the facts of this case, I'm compelled by the facts of this case.
Was that something that was brought to the court's attention?
No, Your Honor, it was not. And there was never any motion filed. There are several issues raised that challenge the sentencing order, and there was never any motion filed or objection made when the sentencing order was read aloud to challenge the wording in the order. This is a situation where the court could have easily corrected these issues, and the trial court was never put on notice. The premise of the preservation of errors is that a trial court be given an opportunity to correct such errors before we bring them to the appellate level. So I think that this error could have been easily corrected. This court can find that the judge knew the law and that the statement was just an unfortunate miswording of her obligation in this case and her findings. However, if the court is not persuaded, it's the state's position that, contrary to what my colleague Ms. Kinney has requested, a resentencing proceeding would not be required. All that would be required would be a remand for a simple reentry of the order. There's no reason for an entirely new resentencing proceeding. The issue regarding the mitigation specialist, I would like to kind of elaborate on what my colleague had described in terms of the sentencing memo and how the judge's rulings evolved. The judge didn't come about the having the mitigation specialist testify in a roundabout way, as my colleague had said. She actually did that because defense counsel put on the record, there's two sentencing hearings. I believe they're January 9th of 2023 and January 10th. And you can see kind of how the argument evolves and how the judge changed her ruling at the beginning of that January 10th date, because at the end of the January 9th hearing, defense counsels, both counsel, put on the record that they were objecting to the Muhammad line of cases. The cases were unclear in a situation like this, where a defendant waives a majority of his mitigation. Defense counsel felt that the case law was unclear, that the ABA standards required more, and that they should be able to present additional mitigation. Now, as this court has said in the Figueroa Santa Barbara case, that when a defendant waives a mitigation, counsel has to honor that and then can't present mitigation. And in this case, the judge was in a very sensitive position, because we have defense counsel saying, well, we think that we want to put this mitigation on the record. Sexton saying, well, I know my right, and if you do that, then I'm just going to discharge counsel and proceed without them. So the judge was doing what she felt was best in this situation, which was to allow Sexton to close his case. He presented the only mitigation that he wanted to, which was extremely minimal, and the trial judge called the mitigation specialist as a court witness. Now, she told the parties, I could do this one of two ways. I can order a PSI, and then I'll just get all the information that I'm required to look at. She felt that the case law required her to look at all of the mitigation that's out there. And so she said, I can order a PSI, or you have your mitigation specialist here. I can just have the mitigation specialist tell me what additional mitigation there was that wasn't presented, so that way I can consider all of the mitigation in my sentence. Defense counsel never objected to that. They actually said they were okay with their mitigation specialist reading the mitigation that they had, because a list had already been formed. And I will give Ms. Kenney the benefit that initially the judge did raise this as a post-conviction issue. Let's put a memo in the record saying what all the mitigation was. I won't even look at it. I'll seal it, and then it will be in the record. However, that evolved given what transpired, what counsel said, defense counsel, regarding their concerns about not presenting the mitigation. And what ultimately the judge did was to protect Sexton's rights and to consider all of the mitigation that was in the record. And if we look at really setting aside, and I'm not waiving, I think I made many procedural arguments regarding these claims, but if we set those aside and look at what Ms. Kinney is essentially asking for, the judge, this was such a heavily aggravated case. We have the vulnerable victim aggravator. The victim was 94 years old. She lived alone. She trusted the defendant. He was her lawn maintenance provider. She let him into the house. There was no struggle. And we have the vulnerable victim aggravator. We have HAC. The defendant took her over, struck her at the door when she let her in. A struggle ensued. He broke so many bones in her face, repeatedly striking her face in such a forceful manner. It was such a gruesome death that her eyes were displaced, so many broken bones. And then on top of that, there were the vaginal tears that support during the course of a sexual battery aggravator. So we have this very, very heavily aggravated case. And then the mitigation that Sexton waived, the judge, however, found additional mitigation that he was not asking for, and found even with that the mitigation pales in comparison to the heavy aggravation. If we take away the additional mitigation that she found that he wasn't asking for, it would be the three statutory mitigators, the no significant criminal history, which she gave moderate weight to, I believe it was extreme mental and emotional disturbance, and substantial impairment. If we take those away, then we're only left with one mitigator, and then he asked for additional mitigation regarding his family involvement that was pretty minimal. So I think that this court can be confident in finding that any error, notwithstanding our procedural arguments, but any error here there's no reasonable possibility that the error would have changed the ultimate outcome and the judge's imposing death in this case. With regard to the first issue, the funding, I do want to point out that, again, because Sexton waived most of his mitigation, he made it very clear that he would not have allowed his counsel to put on the mitigation regarding the PET scans and any additional mitigation that his family would have testified to regarding what he perceived as negative, which would be like abuse from his family, sexual abuse. He did not want that presented. I'll also point out, Justice Coriel, I do want to just correct the record in that his sister did not concede during, I don't believe she conceded during the resentencing phase that about the abuse. She had actually testified during the original, well, she didn't testify. She wrote a letter during the original sentencing phase, and she explained the abuse that Sexton suffered. So it wasn't in the record for the resentencing, but counsel knew about this witness. It was Sexton's sister. They knew that he had this history of abuse. Traveling to go and talk to her wouldn't have changed the outcome, especially given that that Sexton's counsels told the judge, Judge Rondolino, who was handling the funding issues, that the mitigation specialist had already reached out to these family members and had spoken to them. So there was no need for additional funding to be granted for travel. I'm not sure I fully understand my colleague's argument regarding switching the standard regarding the ABA guidelines. However, I think that this court has long held that the defendant must show a particularized need when making such requests, and in this case, it just wasn't there. And I will point out that Judge Rondolino actually did grant travel to Texas for Sexton's other sister. The defense attorney had said that while the mitigation specialist was able to speak to the sister in Arkansas, she wasn't able to make contact with this other sister. So Judge Rondolino authorized that travel request and granted her the funds to travel to Texas to speak to that sister. So there was no showing of need. The request was just very bare bones in terms of the travel and the brain scans, just that this is something that's always done. And that's just not enough. And on top of that, I think we can clearly see there's no prejudice given that this line of mitigation was ultimately waived. If there are no further questions, I would respectfully request that this honorable court affirm Sexton's death sentence in this case. Thank you.
Thank you.
I would just say that the funding motions and the hearings were held in early 2019, and the case went to trial in January 2023. Mr. Sexton informed the court in December of 2022 that he was going to use selected mitigation. He never waived his right to have his counsel fully investigate the mitigation. In fact, he said that he wanted the attorneys to do that. And it's impossible to say now what would have turned up if they, in those 3 years, if they'd had the funding to actually do the travel and go and talk to witnesses. I think that the characterization of the mitigation that was actually put on as very minimal is incorrect. There was testimony from his daughter that was very moving testimony about how he had raised his children from infancy until she was taken away from him when she was 11, from a partner that he had built a business with for 10 years, from his sister who he was very involved with and who he was consoling through her own problems and grief over her husband's death. There was evidence about him working as a journalist, about him not having any problem while he'd been in prison, and how he had become a very a very accomplished painter and artist while he was in prison. So none of this at all was even addressed by the trial judge in the sentencing order. And if you would put the sentencing order from 2013 side by side with the sentencing order from 2023, it's an exact replica of what the judge says the mitigation was. And none of that was presented. She just took and copied and pasted from the 2013 order. So there were a lot of procedural errors, and this case should be reversed for a new penalty phase. Thank you.
Thank you very much. We're adjourned.
All rise.